All right, it's official. Luigi Mangione is not a terrorist. According to the state of New York, now the people versus Luigi Mangione, the judge's ruling has made it official. First-degree murder charges in furtherance of an act of terrorism has been dropped. Second-degree murder charges in furtherance of an act of terrorism dropped. Luigi Mangione is not a terrorist, did not meet the definition of terrorism. Let's break down the legal documents and a great ruling by a judge. There's some bad things for Luigi and some good things in here. Mostly good things. Let's talk about that legal document in detail. If you want to break down my opinions about what the judge said, how it was a great day for the American public based on what the judge said, the precedents that are being set in this country based on the judge's ruling. Luigi Mangione, not a terrorist. Let's break in the document. Now I'm going to bring up on screen the legal document that was issued shortly after the court appearance today. This is the people of the state of New York against Luigi Mangione. The breaking news, by the way, this morning, a lot of us were tuned into the court appearance. It happened extremely fast. We saw Luigi Mangione for about 15 seconds. The court hearing took about 15 minutes. I think it was super brief. I was like, when it was done, I was like, wow, of all the things that we have on the table, that was it. But it was a monster ruling by the judge in this case, Judge Carro, who ruled that the state has failed to prove its argument of a act of terrorism. There was insufficient grand jury evidence to say that this was an act of terrorism. Let's break down the legal document. Now, this is a little lengthy because I haven't highlighted nearly the entire, in fact, pretty much the entire thing. I usually highlight the important parts, but so much of it was worthy of commenting on because I'm a long-winded bastard that I'm going to go ahead and read you pretty much the entirety of this ruling and break down the nuances of things that I think were important and why it's important. So that's what you're going to get from me, is my opinions about every little piece of that statement, why it was important and a good day for America as far as our constitutional rights. So again, let me reiterate something. Whether Luigi Mangione shot Brian Thompson or not is still up for debate. Again, he hasn't been proven guilty in a court of law of actually doing the crime. So let's keep that in mind right now. But even if he did so, again, for those people who are a little concerned why you would defend anybody who did something so heinous, let's not violate the law and set this as a precedent to overstretch the word terrorism. That's the key takeaway today. The judge basically agreed, stop using, this is my personal interpretation, stop using the word terrorism to overstep your legal boundaries all the time. That word terrorism is to be used in very specific cases, not to be used every fucking time you want to make a point, pardon my French, every time you want to make a point, you don't call something terrorism. That's the way our country seems to be moving. Let's just call it terrorism and we can throw the book at somebody. No, you can't do that. That's what the judge says in here. I'll try to tone down those F-bombs, so maybe I'll even delete that one out. We'll see. Let's get into this. The people versus the state of New York, Luigi Mangione. Okay, so the people of the state of New York versus Luigi Mangione. Decision and order. This came down today. On December 4th, 2024, this is a statement of fact starting this letter, but it's interesting because I found some things in here I thought were interesting of note. On December 4th, 2024, Brian Thompson, the CEO of United Healthcare, was shot to death outside of the Hilton Hotel in Midtown Manhattan. Video surveillance captured a man wearing a black mask, dressed in black, carrying a backpack, drawing a gun, and shooting Thompson in the back of the leg. This is important for me because, again, you could have people who say, the video shows Luigi Mangione shooting Brian Thompson. No, it does not. The video shows a man with a mask on, dressed in black, shooting Brian Thompson. If that person is Luigi Mangione, that is something that the state has to prove. So good for, again, the judge pointing out that the video shows a man shooting Brian Thompson. It does not say it shows Luigi Mangione shooting Brian Thompson, because that is something that still has to be proven in a court of law. Now, video also established that before the shooting, the man drank from a water bottle and threw it in a nearby trash can, that he dropped a cell phone as he fled the scene, but that he discarded the backpack in Central Park. So there's some establishments of things that happened. Investigators recovered ballistics evidence from the scene, including 3 shell casings, which said depose, delay, and den, D-E-N. That is because that's literally what it said. It was missing the Y. They think it was supposed to be deny. That's in the footnotes. It should have said deny, but the actual words were den because there was a missing letter on there. Had been written. So in other words, those things have been written on the bullet casings. Investigators were able to trace the shooter's movements to a hostel in Upper Manhattan, where he had registered using the name an identification of Mark Rosario, and they also found evidence that he took a train to Philadelphia following the murder. Now, those statements of fact, again, I would nitpick the nuances of that. We don't know for sure that the same shooter. This is my opinion, and I've got articles, I've got videos on this in detail. We don't know that the same person who did the shooting is the same person who went to the hotel, who traveled to this place, because again, law enforcement lost the shooter for some time in Central Park and picked up somebody leaving the park that looked the same. Is that the same person? There's an argument to be made. It's not the same person. So they're going to state here a little bit, hey, we know that we tracked him here afterwards. I'm not sure you do. You lost him off a camera for some time. So that's one of the questions that I have posed before. What if there was a shuffle done in the park and somebody else went out the other side of the park and that was not the same person as the shooter? You can watch videos on that if you want to see my analysis of that. On December 9th, 2024, this is the arrest of Luigi Mangione. On December 9th, 2024, the defendant was arrested at a McDonald's in Altoona, Pennsylvania, after he was recognized by employees who had seen media coverage. Now, stop right there. Yes, in Altoona, Pennsylvania, the official story goes that the McDonald's worker, a McDonald's worker notified the manager. The manager called in and said, hey, by the way, we've got the shooter from New York in our Altoona, Pennsylvania McDonald's. Holy shit. Police officers arrived, and according to the official statement by the prosecution, an officer immediately recognized Luigi Mangione as the shooter in New York and just continued to proceed to basically interrogate him about the shooting. What were you doing in New York? Blah, 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 blah. And so the story goes. That arrest in Altoona, Pennsylvania, I'm not going to beat the hell out of it today. We've done a million videos on it. Was an illegal arrest in New York, or sorry, in Altoona, Pennsylvania. I had something going on behind me and it completely distracted me there. That was an illegal arrest. I've got 4 or 5 videos breaking it down, including the legal documents written by Thomas Dickey, his attorney, and Karen Agnifilo, his attorney in New York. So Thomas Dickey is the attorney in Pennsylvania. And also New York, Karen Agnifilo weighed in on the issue. They're saying that was an illegal arrest. It was an illegal arrest, in my opinion, and I'll stick by that till the end of the day. Will Pennsylvania ever have the nuts to basically admit that arrest was illegal and a violation of Luigi Mangione's rights, because they never read him his Miranda rights while he was under investigation? I said I wasn't going to beat the hell out of it, and I just beat the hell out of it. Let's stop beating the hell out of it. Let's move on. A 9mm gun was recovered from the defendant's backpack, as well as ammunition, a silencer, a fake New Jersey's driver's license in the name of Mark Rosario, cash, a passport, and a notebook in which the defendant had made journal entries. There were also 2 letters in the backpack, one addressed to his family and one to the FBI. Ballistics analysis demonstrated that the shell casings recovered at the scene were fired by the gun found in the backpack. So again, here's some details. I'm not 100% sure we knew about the letter addressed to the family. Maybe I missed that, and I've been covering this from day one. I do know about the letters to the FBI that was in the backpack, allegedly. And here's a statement. Ballistics demonstrated the shell casings recovered at the scene were fired by the gun found in the defendant's backpack. That may be relatively new. Again, there was a lot of argument about whether or not the bullet casings or whatever could actually be traced. The wording they used before was interesting. The wording they used before was consistent with the casings left at the scene. The gun that was found on Luigi Mangione was consistent with the shell casings. That doesn't mean shit. That's like saying a 9mm casing, which is the most common bullet in America, is consistent with a gun that fires 9mm bullets. That can be all that was there on the consistent part. So now comes this wording where it says that the ballistics actually matched, that the bullet casings at the scene did get fired from that gun. I don't know if that's new, and I just missed that somehow. And again, I've been following this case from day one, but I'm also following 4 cases. So forgive me if I miss something from time to time. Interesting point. They're saying the ballistics do prove that the shell casings at the scene were fired by the gun in Luigi Mangione's possession. Now, spoiler alert, that arrest in Altoona, Pennsylvania was illegal. Therefore, the gun itself that fired those bullets should be, in my opinion, fruit of the poisonous tree. And before you accuse me of trying to defend and get all excited to defend a murderer, because, oh my God, if Luigi Mangione did use that gun and he killed Brian Thompson, why are you trying to defend him and get him off on it? I'm not. I'm just trying to follow the law. The law is you can't just do what they did, which is illegally detain Luigi Mangione before reading him his Miranda rights, separating him from his belongings, illegally searching his backpack, and then when they realized they had what they had, repack his backpack, then read him his Miranda rights and pretend like they didn't just fuck themselves by doing it in the order that they did. and they made a major mistake there. Now, that should be therefore fruit of the poisonous tree, and the confession letter they claim that they have, the notebook that they claim that they have, the ballistics match to the gun in his backpack should also all be fruit of the poisonous tree and not allowed in court, which is why it's very odd that New York and the federal government in New York are proceeding with the case using the very evidence that hasn't even been ruled whether that was legal or not. That is an illegal arrest and search and seizure in Pennsylvania. I'll say it for the 27th time, even though I told you I wasn't going to beat the hell out of it. I'm beating the hell out of it. All right, let's move on. DNA analysis also established that the defendant's DNA was on the water bottle found at the scene and on the cell phone and backpack discarded by the shooter. So they're saying flat out his DNA, after they've done a buccal swab of him in Pennsylvania, matches the DNA on those items at the shooting. So he did touch the water bottle, or he did put his lips on it. He did touch the phone. He did touch the backpack. His DNA is on it, and it matches what they've got. That's what they're saying. Sort of, kind of, maybe new confirmation of what they've got in their case. Defendant's fingerprints were also found on the water bottle and a kind bar wrapper found near the scene. So again, they're stating for fact has been confirmed Luigi Mangione's fingerprints are actually on those. Now, again, these are things that would be debated in a court of law when it comes time for trial if the defense is challenging those things. Now, the defendant was indicted for murder in the first degree. Now, here's where we're going to get to the thing. We're going to cite what he was actually charged with, and then we're going to get down in the purple area of my document when I get the purple highlighting, which is the judge's ruling on you didn't meet the burden of proof here. So here's what he's charged with. Defendant was indicted for murder in the first degree, victim killed in furtherance of an act of terrorism as defined by Pennsylvania law, or sorry, PL, not Pennsylvania law, PL 490.05. Now, again, what this is going to point out is in furtherance of an act of terrorism, the judge is ultimately going to say that's not true. You did not meet your burden of proof. Second charge, murder in the second degree as a crime of terrorism. They also failed to prove that. That's what the judge is going to say. You failed to prove those two things. First degree and second degree murder in furtherance of an act of terrorism or a crime of terrorism. You did not meet those definitions. Murder in the second degree, intentional, 2 counts of criminal possessions of a weapon in the second degree and criminal possession of a weapon in the third degree. All of those are still on the table. Those are still there. They are still charging and believe that we're going forward with murder in the second degree with 2 counts of criminal possessions of weapons and second degree weapon charges. So all of that, criminal possession of weapon in the third degree, also 2 counts of criminal possessions of weapon in the third degree. All of that stuff is still on the table. So there is murder on the table, but not in the furtherance of an act of terrorism. That is a huge thing. Also, a huge, huge win for Luigi Mangione is that they've taken first-degree murder off the table. Now, here's why it's huge. Obviously, the sentencing guidelines are different for first-degree versus second-degree murder. Second of all, second-degree murder can be mitigated down to manslaughter if you use some kind of form of insanity or mental duress defense. Now, I've taken a beating online in my own group of people on Discord saying I just said Luigi Mangione was going to accept a plea deal. That's not what I said, and that's not exactly what they said either, but that's the gist that got around, is that, oh my God, Devil's Advocates thinks that Luigi Mangione is going to plead guilty. That's not what I said and what I meant at all. So let me clarify. First of all, when you plead an insanity defense, you are still pleading officially something to this wording, not guilty by reason of insanity, right? It's still a not guilty plea. It's not putting in a guilty plea. So I made a mistake in my wording when I said he may change his plea, and people thought that I was saying that he's going to plead guilty. No, it is still a not guilty plea, not guilty by reason of insanity, not guilty by reason of extreme emotional duress, or EED. That's what we're getting to, is whether or not the plea, the defense, that's the word I should have used. I should have said his defense may change. It may go from, no, my guy didn't do it, prove he even did it, to, yeah, my guy did it, but here's why he did it. Now, here's what you need to understand. When first degree murder was on the table, that wasn't really an option. You cannot mitigate, you cannot reduce first degree murder to manslaughter using the EED or extreme emotional duress or a mental disturbance type defense. You can't mitigate, reduce first degree murder, but you can do that if it's second degree murder. What Karen Agnifilo just accomplished in the courtroom today with Judge Carro's ruling is she got first degree murder taken off the table, which means it's now second degree murder, and second degree murder can be mitigated down to manslaughter. If she decides to defend it as, yes, he did it, but you have to understand why he did it. He was under extreme emotional duress or something like that. If she goes that way, and if second degree murder can be mitigated down to manslaughter, Luigi Mangione can serve as little as 5 years in prison. And keep in mind, 1 year has already been served. He could get probably time served for that. So he could have 4 years left more. It's unimaginable to some people in America that Luigi Mangione could walk, for example, in 4 years over killing somebody. But that's the way it could go if you go with an emotional defense, mental health disturbance kind of issue. So for those of you out there who are really, really upset saying Karen Agnifilo would never betray her client by changing the plea to, yes, he's guilty. No, well, I'm not saying it's a guilty plea. It's still not guilty by reason of insanity, not guilty by the emotional defense. It's still a not guilty plea. I'm not guilty of second degree murder. It's a manslaughter charge. So I had to spend a little time because I got my hackles up when people were saying, oh, devil's advocates now is turning on Luigi Mangione. He's saying that they're going to enter a plea deal. No, I think we've addressed that enough. But hopefully you got an education on how that's going to work out. Because again, I personally believe that Karen Agnifilo could possibly go for, maybe you've got a, again, keep in mind, let me break this down. If they've got what they say they've got, the ballistics match, you've got a confession letter by Luigi Mangione, which by the way, that should be tossed out, that confession letter part, because again, that was an illegal arrest. But if they have overwhelming evidence against her client, in America, people, if they know they're going to lose, because look, you've got all this evidence. How can I argue that I did it? You've got this. If she goes that route to decide, Luigi Mangione is going to spend the rest of his life in jail, because if I try to pretend like he didn't do it and they've got overwhelming evidence that he did and we lose, he goes away for an extremely long time. If we say, okay, yeah, you've got him, he did do it, but you have to understand why, it could change everything. So again, I'm trying to take my emotions out of it. I'm not telling you which way I want it to go. I'm trying to tell you the options Karen Agnifilo has on the table. And this gave her more options, because now she could claim my guy did it, but here's why he did it. Which, by the way, to continue a long process I said a million times, is the same thing, in my opinion, as putting the healthcare system on trial, which I said this case may do. And a lot of people said, even lawyers and attorneys have come on my channel and said, I just don't know how Karen can turn this into putting the healthcare system on trial. They will argue, and I've said this myself, the prosecution will argue, Your Honor, Luigi Mangione's not on trial for the healthcare system. He's on trial for shooting Brian Thompson. We're not putting the United Healthcare System is not on trial here. Luigi Mangione is. And I would expect them to uphold that. That's true. Luigi Mangione's on trial, not the American healthcare system. However, if you claim an emotional duress, you have to explain to a jury why you're under emotional duress. Guess what you have to do if you have to explain that? You have to explain how the healthcare system put Luigi Mangione under a mental duress. Therefore, the healthcare system effectively gets put on trial, which is what I said from the beginning, that this could be putting the American healthcare system on trial. Now, I'm beating the hell out of this, and we haven't even gotten barely into this document. I want to point out one more thing. The federal case still exists. Now, the federal government, the Southern District of New York versus Luigi Mangione, they don't have first and second degree murder. What they have is a murder charge with aggravating circumstances. So it's not a first degree or a second degree murder type of situation. And the EED defense or emotional defense doesn't come into play there in the same way. There's not first degree murder there. It's just murder, but it has aggravating circumstances. The aggravating circumstances is what the government's using in the Southern District of New York to try to execute Luigi Mangione, to put him to death. And what Karen has argued is this is unfair to Luigi Mangione, because what we do in the state case could prejudice him in the federal case. Let me give you one example, and it may not be the one she was going on, but one example. If Karen Agnifilo, for example, who just got first degree murder in the state case removed, and now it's a second degree murder charge, and if she wants to argue, okay, yeah, you've got enough evidence to convict him, so let's go for the fact that he was under extreme emotional defense or duress, and let's explain why he got into that state. And by the way, all a jury has to do is understand how Luigi got there. They don't have to believe that they would have got there. They did. All the jury needs to do in an emotional defense is say, can I see how Luigi Mangione got to that position? And if so, then they can mitigate that to manslaughter. I don't know if you're following all this. But the problem is, and that's what Karen's arguing, is in order for us to say, hey, baby, maybe he did it, and maybe he did it because he was under extreme emotional defense, you're making me admit to the federal government that, yeah, he did it. And they don't have that option on the federal government. So it's unfair to our guy to make his prosecute or to defend this case in two different ways in two different court systems with two completely different rules. And the bad news at the end of the day is the judge is saying, we're not going to change anything about that. You're still going to face Luigi Mangione is still going to face a court case in the state and the federal government. So when I started out this video, I told you there's some good things and there's some bad things. There's the spoiler alert. The bad thing is the judge said, no, we're not tossing out the state case or the federal case. You're going to have both cases. You've been denied. We will have both trials. And I don't care, essentially, is what he's saying. I don't care that Luigi Mangione has to defend himself two completely different ways in two completely different trials. Deal with it. It's allowed by law. And so that's the bad news. But let's get back to the good news. Now, the defendant has filed an omnibus motion. So that's Karen Agnifilo on behalf of Luigi Mangione filed an omnibus motion seeking Huntley, Mapp, and Mosley hearings. This is relating to suppression of information, suppression of the evidence, tossing things out because they did things illegally, like arresting him in Pennsylvania and violating his and not reading his Miranda rights. All that kind of stuff is still having hearings. And the defendant also moves to dismiss the terrorism charges. So this is what they were kind of potentially here for today. A bunch of motions to have hearings on whether or not evidence should be dismissed entirely, and to dismiss the terrorism charges, and to dismiss the entire indictment for alleged violations of double jeopardy clause. So again, Karen has filed, let's just toss this whole thing out. You can't try him in two different jurisdictions at the same time. It's not fair. And argues that the state case should be stayed. The state case should be stayed pending resolution of a concurrent federal case. In other words, you should postpone or drop the whole state case and let us focus on the federal case, which is the higher case, which requires death. So if we're going to fight a death penalty case, stay this case, put it on hold, and let us fight the federal case. And essentially, what Karen Agnifilo is arguing is if you put the state case on hold, if you stay the state case until after the federal, sorry for that, if you stay the state case until after the federal case is done, her argument, which she's already started to lay down, is the federal government, whatever they decide, is good enough. That decision will be good enough. It'll make the state case a moot point. If the federal government has already ruled on it and it's the higher case with the death on the line, if they rule on it, it makes the state case immaterial. There's no reason to go through with it. The highest court and the highest punishment possible has already been ruled on. Why have the state case? But again, the judge ultimately said, no, we're not going to stay. We're not going to postpone the state case. We're going forward full steam ahead. That's the bad news for Luigi Mangione. All right. And so the people responded and said that they can. Okay, so the people, that's the state, filed a response consenting to pretrial hearings. So they're okay with having the hearings about the suppression of evidence, but oppose the motions to dismiss and stay the proceedings. So that's the thing. The prosecution has agreed. Sure, let's have hearings on whether or not everything that we've presented against your client is admissible. We're okay with having those hearings. Let's have those hearings. But we reject this idea that you want to dismiss the case entirely or put it on hold. And so that's what he's ruling on, is those things, right? So in the suppression hearing issue, here's what he says. The defendant's motion to inspect grand jury minutes for legal sufficiency pursuant to whatever is granted. Now, let me explain this. A grand jury is convened in private without the defense there at all, just simply in the early stages of a case to decide whether or not it's worth the state's time to pursue it. So a grand jury is convened of everyday citizens to look at the evidence the prosecution and the prosecution alone has to say, does the prosecution have enough evidence to go to trial? That's the job of a grand jury. They do not hear from the defense. And oftentimes the defense doesn't get to hear what happened in that grand jury. It's just an answer. Yes, the grand jury decided it's worth going to trial. There's a famous saying that says you can get a grand jury to indict a ham sandwich. They almost always indict. But in this case, guess what? The grand jury did not find enough evidence to proceed with the terrorism charges. That's the amazing part. Even though you can get a grand jury to indict a ham sandwich, they didn't agree that it was an act of terrorism. And so the judge has agreed that the defendant has a right to look at the jury minutes so that they can read what the grand jury thought and what they were thinking. So that's a win for them. The standard of review for legal sufficiency is whether there is competent evidence which, if accepted as true, would establish every element of an offense charged and the defendant's commission thereof. Legally sufficient evidence means a prima facie case, not proof beyond a reasonable doubt. It basically just means, is there on face value, what's what prima facie basically means. On face value, is there enough information? Let's not talk about whether or not the defense can argue it to death. Is there on face value, just based on what you said, is there enough evidence to proceed? And that's what they were looking at. A court must consider whether the evidence viewed in the light most favorable to the people, if unexplained and uncontradicted, would warrant conviction by a petite jury. So this is the key. A grand jury's whole purpose is not even to hear the defense. It's like, does the prosecution have enough? Understanding, of course, the defense is going to argue about it, but do they have enough without the defense opening their mouth to proceed? And that's the whole job of the grand jury. Do they have enough without the defense opening their mouth to proceed? Because sometimes they don't even have enough to proceed before they've even heard the defense's argument. Here, the defendant argues, that's Luigi Mangione, argues that there is legal insufficient evidence of first-degree murder, alleging that the victim was killed in furtherance of an act of terrorism. So Karen Niffler said this is not an act of terrorism. That's what their argument is. And also, there's insufficient evidence of second-degree murder as an act or crime of terrorism, and urges the court to dismiss those two counts of indictment. Defendant argues that both legislative intent and case law demonstrate that the defendant's actions do not fit within the statute and that the people did not present legally sufficient evidence of those counts. Again, spoiler alert, that's exactly what the judge ruled. The judge said, you are right, Karen Niffler and Luigi Mangione. The state did not meet its burden to prove it's an act of terrorism. It is not terrorism. And the best part about it, what I want to get to hopefully in this video, is the language he used to clarify for America. You can't freaking use the word terrorism on everything to throw the book at people because it's a really great tool. You can't do that. Terrorism is a very specific thing. You failed, state, to present terrorism. Stop using it in such a flippant way. That's my universal translator of the judge's response. The people argue that both counts. So this is the people. Now the state's arguing, no, judge, it's totally legitimate. The people argue that both counts are legally sufficient and that terroristic intent was established because the defendant was not engaged in a personal vendetta, but violently broadcast a social and political message that inspired threats to employees of UHC. So in other words, they're saying Luigi Mangione intended to wage war against the healthcare system. Therefore, it's an act of terrorism. It wasn't just him in a beef with Brian Thompson, which would have been not a terrorist act, but it was against the whole industry. That's their argument. New York's terrorism statute set forth in Article 490 of the penal law, that's what PL was earlier, not Pennsylvania or whatever the hell I was trying to say, it's penal law, was enacted on September 17th, 2001. This is an amazing statement. I want to highlight this. New York's terrorism statute set forth in Article 490 of the penal law was enacted on September 17th, 2001, just 6 days after the September 11th attacks. The legislature was able to so quickly act because it liberally borrowed from already existing federal legislation. What the judge is stating is the whole terrorism law that you're using to bring against Luigi Mangione as a terrorist was enacted only 6 days after September 11th, and it quickly rushed through an approved law that was never intended to be used the way that you're using it. Go screw yourself. There you go. I'm adding that on behalf of Judge Carro. I'm sure he did not feel that way. But the point, what he's saying is, yeah, that legislation that you're trying to use to call Luigi Mangione as a terrorist was rushed in the first place and was never intended to be used the way that you're using it. The legislative findings state that the devastating consequences of the recent barbaric attack. So he's quoting this whole thing they're using to Luigi Mangione is a terrorist is something that was put into place right after September 11th, and it was stated. The legislative findings state that the devastating consequences of the recent barbaric attack on the World Trade Center and Pentagon established a compelling need for legislation designed to combat the evils of terrorism. Well, guess what? You can't, right off the bat, you're using legislation designed to combat something on the level of bringing down twin towers and killing 3,000 people and saying that somehow it applies to a random shooting or a not so random shooting on the street of New York against one guy. You can't do that. That's what the judge is getting to. The examples of terrorism cited in the legislative findings are 1, September 11th themselves, 2, the bombing of the American embassies in Kenya and Tanzania in 1998, 3, the destruction of the Oklahoma City Federal Building, the Morrow Building in 1995, 4, the bombing of Pan Am Flight 103 in Lockerbie, Scotland in 1988. 5, the 1999 shooting from atop of Empire State Building. 6, the 1995 murder of Ari Halberstrom from the New York Bridge. And 7, the bombing of the World Trade Center in 1993. Not, on face value, anyone in their right mind would realize none of those things that were the basis of that law have anything to do with one guy shooting one guy in the street of New York. You're misapplying the law, and thank God the judge had the balls to just say so. No, you can't do that. That law was never intended that way, and you know it. Under Penal Law 125.27, 1, a person commits first-degree murder when, with the intent to cause the death of another person, he causes the death of such a person, and the victim was killed, quote, in furtherance of an act of terrorism, as defined. Under Article such and such, such and such, a person is guilty of first-degree murder when they engage in activities that involve a violent act or acts dangerous to human life that are intended to, quote, intimidate or coerce a civilian population, influence the policy of a unit of government by intimidation or coercion, or affect the conduct of a unit of government by murder, assassination, and kidnapping. Those are the two things that the state was using to say Luigi Mangione is a terrorist. He did it as an act of terrorism, because he was trying to influence government policy, it's an extreme thing, none of which is true. Similarly, a person is guilty of second-degree murder as an act of terrorism when he commits a specific offense, including second-degree murder, that is intended to intimidate or coerce a civilian population influenced by the policy of a unit of government by intimidation, coercion, or affect the conduct of a unit of government by murder, assassination, or kidnapping. All right, here's the great part. That's what the charges that are on the table. Purple now is where the judge is responding with what his interpretation is. And the wording is so great. It's like chef's kiss. Good shit right here. The people assert that they have established all three intents, although they focus on intimidating or coercing a civilian population. Yet, they also briefly argue that the defendant intended to influence or affect the policy of a unit of government by intimidation or coercion through his actions. There was insufficient evidence presented in the grand jury to support this claim. So the grand jury didn't buy it. The evidence is not good enough. There was no evidence presented that the defendant made any demands of government or sought any particular government policy change, let alone that he did so by intimidation or coercion. Thank you, judge. That's exactly what Karen was saying. Where in the world is Luigi Mangione threatening the government? And the judge is like, you know what? You proved nothing that Luigi Mangione was trying to threaten the government. Pack sand. That is not true. You can't use that. That the defendant was motivated by animus. So the judge goes on. That the defendant was motivated by animus or animosity towards law enforcement did not establish an attempt to influence government policy through his actions. So in other words, he can have a beef with law enforcement, and that doesn't mean he's trying to influence government policy. Those are two separate things. The defendant's statement about the need for change, they got in quote, it is insufficient to establish an attempt to influence policy as opposed to expressing anger. If I say law enforcement is broken in America, the judicial system is broken in America, I'm not a freaking terrorist, and neither is Luigi Mangione. That's how that breaks down. Evidence established that the defendant specifically intended to influence the Department of Social Services policy. Indeed, as the federal authorities noted, the defendant's goal appeared to be to draw public attention to what he perceived as a problem with the healthcare industry. The people placed great emphasis on the snatched phrase, revolutionary anarchism. Oh my God, yes. The people of the people versus Luigi Mangione used Luigi Mangione believes himself to be a revolutionary anarchist while he was quoting Ted Kaczynski about the Unabomber situation, and the judge, oh my God, chef's kiss for the judge. The judge understood exactly how the term was used, called the state out for misapplying the revolutionary anarchist thing that they're claiming Luigi Mangione was calling himself, and even had, oh my God, I love this, and even had the nuts to tell the prosecution, dude, the defendant literally tried to distinguish himself from Ted Kaczynski, and how did you miss that? And I said that too. I was raging hell. Like, Luigi literally said, I don't respect Ted Kaczynski because he hurt innocent people. That's not what I'm doing here. And the judge caught it and said, yeah, Luigi Mangione didn't intend to kill innocent people. It was even pointed out in his writings, you SOBs, my universal translator. All right. So The defendant in his writing suggested this satisfies the statutory element of intent to influence the policy of a unit of government by intimidation or coercion, or affect the conduct of a unit of government by murder, assassination, or kidnapping. Not only does this stretch, this is what the judge says, not only does this stretch the import of the two-word phrase revolutionary anarchist that they quoted that Luigi Mangione is a revolutionary anarchist. He's a revolutionary anarchist. And the judge is calling him out on that. Not only are you stretching the two-word phrase revolutionary anarchist beyond what it was intended to carry, but it ignores other more explicit excerpts from the defendant's writings in which he states that his goal was to spread a message and to win public support. So he's not attacking the government. He's trying to win public support according to what's in the writings. Some of those writings, by the way, we haven't seen in detail. So they're clearly talking about things that we haven't necessarily seen. That Luigi Mangione wanted to send a message to win public support, but that's not the same as being anti-government and trying to affect government change. He's trying to impact. What the judge is saying is, if anything, Luigi Mangione is trying to sway public opinion, not government. He's not trying to sway the public or the government. He's trying to sway the public. And about everything wrong with our health system. So Luigi Mangione's message was to win public support and to show what's wrong with our healthcare system. That is not trying to influence a government policy. It's public perception. Therefore, the court finds that the people failed to establish an intent to influence or affect the government. Again, what he's saying is, if you listen to what Luigi wrote in those writings that you're attributing to him, his intent wasn't to go after the government or change policy. It was to win public support for people to be paying attention to how bad healthcare is in America. That's not the same thing as affecting government change. It's public opinion. This court will focus on the intent element that both sides appear to emphasize the intimidation or coercion of a civilian population. So now he's going to focus on that bullshit. The court will note that the term terrorism has been famously difficult to define. Our Court of Appeals has cautioned against expanding the definition of terrorism beyond what the legislature intended. That's exactly what I was saying. Law enforcement will continue to press the definition of terrorism so they can call everything in America an act of terrorism because they have way more power when fighting terrorism. So now all of a sudden you're a domestic terrorist, you're an eco-terrorist, you're a, whatever. Just throw the word terrorism onto something, and then you can use all the terrorism laws, which basically go way beyond the intent of any of our law to go after terrorists, and you can't do that. That's what the judge is saying. Thank God this judge has the wherewithal to understand that, and this is setting precedent in America that you can't use terrorism laws against anybody you want to by broadly using it in this fashion. The concept of terrorism has a unique meaning, the judge goes on to say. Its implications risk being trivialized by the terminology is applied loosely in situations that do not match our collective understanding of what constitutes a terrorist act. I didn't read that well, but what he's saying is you are trivializing the word terrorism if you apply it to everything. That's what he's saying. The legislature incorporated a generic or general definition of the crime and referenced 7 notorious acts of terrorism to serve as guideposts for determining whether or not a future incident qualifies for a nefarious designation. So when they wrote the terrorism law, they said, here's the examples of how that would be applied. When you're bombing the World Trade Center, when you're flying planes into the World Trade Center, when you're shooting random people from a high place in a city. Those are kind of the acts of terrorism, not one guy shooting one guy in the street of New York City. As noted above, those notorious acts include massive death and destruction of September 11th, and he goes on to name all of those things. We don't need to read that. Then he gets into this Morales thing. They try to use, here's the thing, and I try to wrap this up as quickly as possible and not beat this to death. So one could argue that when a gang shoots somebody publicly in the streets of America, it sends a message to the entire population, don't screw with our gang, right? So one could argue any gang shooting in America is an act of terrorism. It's designed to influence a civilian population. I'm going to commit an act of murder right in front of everyone so that you all know to shut your effing mouth about what the gangs do. This could happen because we'll do it right out in front of you, and it terrorizes the population. And so someone had tried, court cases have tried, to apply gang shootings to be a terrorist act because it's intended, and one could see the logic, to terrorize the population, to make people afraid to stand up against the gangs. And yet our court systems have ruled, no, that's not an act of terrorism. And that's what the judge is going to spend some time explaining. I don't know if I want to go through it all. I'm going to start making an attempt. And if I breeze through it a little bit, it's because it's lengthy. In Morales, which is the case that they're using, the defendant was a street gang member operating in a particular area of the Bronx. At a christening party, the defendant fired 5 shots at one of his rivals, who was paralyzed. The shots also killed a 10-year-old girl. The prosecution argued that there was sufficient evidence of terrorism because the defendant intended to intimidate or coerce other Mexican American gangs and by inference, all Mexican Americans in the geopolitical area. The appellate division dismissed the terrorism conviction, finding that there was no intent shown to intimidate or coerce the Mexican American population residing in the particular area of the Bronx. The court also found that members of other Mexican American gangs in that area of the Bronx did not qualify as a civilian population. So this is the key points the judge is making. One, they didn't call it an act of terrorism, the appellate courts, because of what was done, and they didn't call the Mexican Americans a civilian population. In this case, the people of New York versus Luigi Mangione are trying to claim that healthcare workers are a civilian population. And so what the judge is saying is, just like Mexican Americans in this case do not constitute a civilian population, so also do United Healthcare workers or the medical industry not qualify as a civilian population. That's what the appellate courts have established. It's not how you use that. The court also found that, when I read that sentence, examining the legislative findings and the examples of terrorism listed, it is clear that the legislator intended to address extraordinary criminal acts perpetrated for the purpose of intimidating a broad range of people, not a narrowly defined group of participants or individuals. So the judge is saying, no, people versus New York, the state cannot use the idea of Luigi Mangione intimidated the healthcare industry to say that it falls under this thing. No, it doesn't. The appellate court said a narrow group of people does not constitute the civilian population. Therefore, even the healthcare industry does not constitute a civilian population. You can't use it. Let's skip on a little bit. The Court of Appeals affirmed the appellate division's dismissal of terrorism convictions. So again, the appellate courts agreed that was wrong, and it was upheld that it was wrong to use it in that way. The court noted that the statute did not define the phrase intent to intimidate or coerce a civilian population, but it stated that it should be given in the most natural and obvious meaning based on common sense and reasonableness. Civilian population could not be broadly used to encompass a variety of communities depending on how or what area is defined or who lives within the territory. The court found it unnecessary to precisely define the term civilian population, but it concluded that even if all Mexican Americans living in the particular area could be considered a civilian population, the evidence did not demonstrate that the defendant committed this discrete act with the conscious objective of intimidating every Mexican American in the territory identified. Basically, a long way of saying you can't use it this way, which is great, and he's spelling out why. Moreover, the court found that there was no indication that the legislature enacted Article 490 with the intent to elevate gang-on-gang street violence to the status of terrorism, or as the concept is commonly understood. So again, they specifically ruled you can't just use this for gang-related stuff. So how are you going to use it for Luigi Mangione? Let's skip past this. I don't think it's important to get all of the nuances of Morales, so I'm going to skip past Morales. This is more about Morales. In the sake of brevity, because I like to keep these at about an hour, I'm going to skip through a lot of that Morales. On screen, however, you can go, if you don't mind scrolling around, you can pause the screen and read it for yourself, or you can go get the document that's available widely online. All right. Notably, the federal authorities, while recognizing that Brian Thompson was gunned down in cold blood, did not charge the defendant with. So this is important. The federal government. Now, keep in mind, this is the state case. I didn't catch how important this is to bring this out. This is the state versus Luigi Mangione. Luigi Mangione is also facing federal charges in the state of New York. 2 different jurisdictions, both in New York. One's the state, one's the federal government. What the judge is going to point out now is that the terrorism charge that the state is using against Luigi Mangione started as a federal legislation. And the state adopted the federal guidelines to apply to the state case. if that isn't confusing enough. And so what he's pointing out is, guess what? The federal government who's charging Luigi Mangione isn't calling it an act of terrorism. So how is it you use their document on what defines an act of terrorism and call it terrorism when you're using the federal government's guideline and the federal government is not calling Luigi Mangione a terrorist? Are you following the logic? The federal government wrote the rules on what is an act of terrorism. The state used those rules and said Luigi Mangione is a terrorist, while failing to realize that the federal government themselves is not charging Luigi Mangione with an act of terrorism because, as the judge is saying, the federal government knows it's not terrorism. So you also should know it's not terrorism. Shame on you. Let's read it now after I got through the universal translator. Notably, the federal authorities, while recognizing that Brian Thompson was gunned down in cold blood, did not charge the defendant with crimes of terror. The federal government didn't charge him with terrorism, but they charged him with using a firearm to commit murder and related crimes, even though the federal terrorism statute served as a model for the state. So again, the federal government has that document about what this is terrorism, and they didn't charge him with terrorism because they know it's not terrorism. Why didn't you figure that out? Regarding the defendant's intent, the acting United States attorney for the Southern District of New York stated that the defendant's goal was a grossly misguided attempt to broadcast his views across the country. So that's what they're saying. Luigi Mangione had a bad idea that he could get his views across by shooting somebody. The assistant director of the FBI stated that the defendant committed murder to incite national debate, and that he deemed murder an appropriate recourse to satiate personal grievances. So what they're saying is the federal government recognized this is a personal thing to get national debate going. It's not an act of terrorism. It wasn't an attack on the government. It was designed to create national discussion. Therefore, the federal government was smart enough to realize it wasn't terrorism, and the state should have done as well. The people suggested that the element of intimidation and coercion can be met because some United Healthcare employees felt fearful after the murder, and some United Healthcare employees received threats. But putting aside that some employees received threats even before the murder, one so serious that investigators traveled to another state to investigate, and every murder has the potential to induce some degree of fear. This is an amazing sentence by the judge. What he's saying is, just like Karen Nicola pointed out, the state wants to argue Luigi Mangione terrified United Healthcare individuals who worked there, and they were afraid. And yet death threats against United Healthcare were coming in before the shooting. So how did Luigi Mangione act any differently? They were afraid of death threats in general, not just Luigi Mangione, and Karen proved. United Healthcare had been receiving death threats well before Brian Thompson was shot. So it's not a Luigi Mangione thing. So if your people are afraid of what's happening out there and America's sentiment getting angry at the healthcare system, it's not Luigi Mangione's problem. It's your bigger problem. You've had death threats before Luigi Mangione. And furthermore, it says, for example, a random murder on the subway will cause rioters to be fearful. So what they're saying is, yes, of course, people are afraid when somebody gets killed. That's normal. The law was designed for extreme cases. By definition, if somebody gets shot and killed, people become fearful. That is by definition. That's not what the intent of the rule was. You don't just write, hey, by the way, you can charge somebody with terrorism if they're afraid after somebody got killed. No, you cannot. That's by definition. People are going to be afraid after somebody gets killed. So that's what he's saying there. Using these guideposts of the 7 examples as directed by Morales, is similarly not comparable to the examples listed in the statute. There is no evidence presented of a desire to terrorize the public, inspire widespread fear, engage in a broad campaign of violence, or to conspire with organized terrorist groups. That's important. The judge is admitting Luigi Mangione isn't trying to inspire terror. The media wants to keep running with this narrative that Luigi Mangione is inspiring other people to shoot people. Oh, Shane Tamara went out and killed people in New York because he was inspired by Luigi Mangione. I'm waiting for them to tell you that Charlie Kirk was shot and killed by somebody inspired by Luigi Mangione, that Luigi Mangione was inspiring people to commit acts of violence. The judge is saying, no, sirs. Luigi Mangione is not inspiring the public to murder. That's a media narrative. That's essentially what he's saying, in my opinion. There was no evidence there was no evidence presented of a desire to terrorize the public, inspire widespread. We already read that. Here the crime, the heinous but targeted and discreet killing of one person, is very different from the examples of terrorism set forth in the statute. So again, the judge is saying, hey, this is a bad thing that he shot and killed somebody. It is completely different, however, than a terrorist act. The examples cited in the statute share similar characteristics of indiscriminate killing, which produce fear and terror, whether through bombing or through indiscriminate shooting of multiple victims. So what the judge is pointing out is random people were attacked. Shooting from the top of a building at a crowd of people, for example, is a random act. But this was a targeted thing against one person. It is not even close to the examples you guys have used as a terrorist act. So we'll get past that because it seems like we're beating a dead horse and we're reaching about the 10 minutes till the end and we're on pace. This court need not reach the issue of whether the statute encompasses an act that only involves a single victim, but the court will note that the people's reliance on two of the examples set forth in the statute, the Empire shooting and the Ari Harbertson's killing on the Brooklyn Bridge, as incidents that encompasses only one victim, are misplaced. Now, I know I just read that super weird. What it's saying is the state tried to argue, hey, Your Honor, it's not just mass killings that the Terrorism Act applied to, because in a couple cases, it was one individual that was killed. And the judge is smart enough again to say, I cry bullshit. Yes, two cases that you cite where one individual was killed as an act of terrorism was when somebody was firing into a crowd of people indiscriminately and only one person got killed. That is completely different than one person targeted, one person killed. So you trying to say, hey, look, we've used terrorism before when only one person was killed. Yeah, when they're shooting into a group of people indiscriminately and one person got killed, that's been applied that way. Shame on you for trying to apply it that way, you sons of bitches. That's not Judge Carro's words, that's mine. All right. Those incidents were very different from the one presented here in the 19. And so he just basically explains what I just explained. We don't have to go into that for the sake of time. While there is no doubt that the crime at issue here is not ordinary street crime, it does not follow that all non-street crimes are meant to be included with the reach of terrorism statute. So again, street crimes aren't meant to be applied to terrorism. While the people place great emphasis on the defendant's ideological motive, there is no indication that in the statute that a murder committed for ideological reasons, in this case, the defendant's apparent desire to draw attention to what he perceived as inadequacies or inequalities or greed within the American healthcare system, fits the definition of terrorism. It doesn't fit. Without establishing the necessary element of intent to intimidate or coerce, the court agrees with the defendant that the people appear to conflate an ideological belief with the intent to intimidate or coerce the civilian population. So he agrees. Karen Agnifilo is correct. While the defendant was clearly expressing animus towards United Healthcare and the healthcare industry generally, it does not follow that his goal was to intimidate and coerce the civilian population, and indeed, there was no evidence presented of such a goal. As the third department recently held, we look to the acts of violence in this case with the guideposts of specific acts of terrorism referenced in the statute. So again, it doesn't rise to the level of an attack on the World Trade Centers. Defendant argues that concurrent state. So that was it. That is why the judge dropped the terrorism thing. It's not terrorism, and he stated in great wording that will be used in other court cases why that is not an act of terrorism. You cannot take the shooting of one man and apply it as an act of terrorism. You're overstating, and he did brilliantly with it. Congratulations, Judge Carro. Now, we're dealing with the double jeopardy issue, and then we'll be out of this document, I believe. The defendant argues, this is a different issue, the defendant argues that concurrent state and federal prosecutions violate the double jeopardy clause of the United States Constitution, barring the prosecution for two offenses based on the same act or criminal transaction. So again, Karen Agnifilo is saying it's not fair to Luigi Mangione to have to fight two different jurisdictions at the same time for the same offense. However, the judge says, as the United States Supreme Court held, where there are two sovereigns, that's the Southern District of New York and the state of New York, where there are two sovereigns, there are two laws and two offenses. So again, they have different laws, they have different rules, they are two separate sovereigns, and so therefore they can prosecute them at the same time. Not a good thing for Luigi Mangione that the judge is upholding that he can be tried twice, essentially for the same crime, because each one of them have different laws and they're being applied differently, and he has to defend in both. Not a good win for Luigi Mangione. A crime against two sovereigns constitutes two offenses because each sovereign has an interest to vindicate. So that's why he's saying, so there is no double jeopardy. So the judge denied the double jeopardy and will proceed with going to court in the state case and the federal case. That's what he's ruling. We're not going to dismiss the state case because it's not double jeopardy. You are wrong about that. Not a good win for Luigi Mangione. Looking at the time, we got a few minutes left to continue on. While it's true that this particular penal law grants greater protection than that of the state or federal constitution. That bar is triggered only when a prior prosecution ends in a conviction by guilty plea or once a jury has been sworn. Therefore, because neither event has occurred, the defendant's motion is premature. This is an interesting paragraph. What it basically says is you might be able to argue something about double jeopardy after a guilty verdict is rendered. But because no guilty verdict has been rendered, it's premature. So it's almost saying you can make this argument again at a later time. Defendant nevertheless argues that he is prejudiced by concurrent proceedings because he will be forced to litigate a federal case in which he faces the death penalty while the state case is proceeding to trial, and that testifying in the state case may prejudice him during his federal trial. Yes, if in the state case you say, yeah, I did it, but here's why I did it, because I'm going to take the emotion or the extreme emotional defense route, then you're admitting to the federal government that you did it, and that's going to prejudice you in that case by definition. Now, I'm not saying that's what Karen Agnifilo is going to do, but that's an example of why how you defend one case may ruin the other case. The defendant suggests that the federal case should proceed first, even though the federal and the state authorities have agreed that the state case should proceed first. Because again, my belief, what Karen is trying to do is that the federal government is the higher case, right? It's the one that has death on the line. If you go to court in the federal case and Luigi Mangione is found guilty or innocent, there's no reason to try him again in another case. The highest court in the land has decided the issue. Why would a lesser court need to rule in on the issue? Is kind of what she's saying in a short order. I'm probably not getting it exactly right, but that's the gist of it. This court is not persuaded. So the judge says, nope, I hear your argument and I award you no points. Anyways, so this court is not persuaded that proceeding to trial in the state case first will cause the defendant severe prejudice, and the defendant's claim that any state trial testimony will prejudice his federal trial. So I don't agree with the judge. I think that what happens in the state case is going to prejudice the federal case. So I disagree with the judge in this opinion, but I'm not a lawyer. I'm not a judge. I'm not a law professional. My personal opinion is I disagree with his ruling that it's not going to impact the other case. It will impact the other case, in my opinion. Moreover, the defendant cites no case law or authority that would permit such a proactive adjournment, as even the defendant concedes that the federal case will take several years before trial. The court is also confident that counsel will have the capability to manage an approximately 2-month state trial during the pendency of several years before the federal case proceeds to trial. So what the judge is saying is, look, everyone knows the federal case is going to take years to even start going to trial. This state case is going to be over in a couple of months. So it'll be long done and out of everybody's mind by the time the federal case proceeds. So it doesn't impede with your ability to defend the federal case. Now, Avi Moskowitz, the specialist in the death penalty, who's working with Karen Agnifilo on Luigi's case, is arguing, well, that might be true that we're not going to court for Luigi Mangione in the federal case for potentially years. When death is on the line, we have to start preparing for the death case immediately, right now. And us fighting a case in the state while we're trying to prepare for the upcoming death penalty thing, because we have to prepare for that now. We are required to start to prepare for that immediately when death is on the line. So we're already in this. You say the case doesn't start, a court case doesn't start for a couple of years, but we have to start working on that death penalty issue right now, and you are prejudicing that. And I kind of agree with that. In summary, counts 1 and 2, charging the defendant with murder in the first degree in furtherance of an act of terrorism and murder in the second degree as a crime of terrorism, are dismissed as legally insufficient. The people presented legal sufficiency evidence of all other counts, including the murder in second degree intentional. Thus, the motion to dismiss is denied in all other respects. The motion to stay, as is the motion to stay the proceedings. This constitutes the decision of the court. Ultimate conclusion: murder in furtherance of terrorism in the first and second degree dropped. Everything else still on the table, and we will proceed to trial. Thank you for listening to my breakdown of the legal analysis. In the end, this was a big win for Luigi Mangione's defense team because they removed first-degree murder from the table. It gives them more options to potentially, and I realize it's not a popular thing with some of you. There are many of you out there who believe Luigi Mangione did not do this. He's completely innocent and he's being framed. So you don't want to hear any argument that says that Luigi Mangione might say, yeah, I did it, and here's why I did it. But that's where I personally feel the case is going. I feel that's how you put the American healthcare system on trial. I'm not telling you which way that I want it to go. I'm telling you my analysis of how I think it's going to go. So for what it's worth, hope you will stay with Devil's Advocates as I break down these legal documents for you. Thanks for listening and have a great day.